Chapter 29. Forgery. Section 516. Definition and Essentials. Forgery, at common law, as defined by Blackstone, is the fraudulent making or altering of a writing to the prejudice of another's right. In its broadest sense, it includes the making or altering of any writing or record with the intent to prejudice the interest or right of another. It is essential that the making or altering be false and be done with intent to deceive. 3. Section 517. Nature of the instrument. The document must possess at least apparent legal efficacy. It is not forgery to make or alter a void instrument. Hence it is not forgery to alter a will that is not signed. Any instrument which may be the basis of a suit against another can be the object of forgery at common law. Thus, deeds, wills, invoices, bank checks, money orders, deposit slips, receipts, records, book entries, orders for the delivery of goods, railway and other tickets, certificates of character, affidavits, acceptance of service and waiver of citation in petition for divorce, chattel mortgages, endorsements on notes, subscription lists, seals of corporations, orders for credit, due bills, warrants on county treasury, and bills of lading, have been held capable of being forged. Making a false endorsement on an instrument is a forgery. On the other hand, agreements to pay for advertisements, applications for insurance policies, invalid affidavits and mere complimentary letters of introduction, have been held not capable of being forged. Section 518. Imitating another's trademark or label. Whether to imitate another's trademark or label is forgery or not depends upon whether it can be made the basis of a suit against the imitator or not in an action for deceit or warranty. Thus, in an English case, 33, where the proof showed that the defendant obtained from a printer 10,000 labels resembling those used on Boyke's baking and egg powders and put them on packages resembling Boyke's and sold many of them, the conviction of forgery was quashed by the higher court. The defendant was found guilty of fraud, but the fraud consisted in selling spurious powders as real ones. To constitute forgery, the document itself must be the instrument of the fraud. As said by the court, the fraud consists in putting inside the wrappers powder which is not genuine, and selling that. If the prisoner had had 100 genuine wrappers and 100 not genuine, and had put genuine powder in the spurious wrappers and spurious powder into the genuine wrappers, he would not have been guilty of forgery. Section 519. Fraudulently assuming authority to sign another's name. It is not forgery for a person fraudulently to assume authority to sign another's name to a document, where the defendant fraudulently represented that he was a member of Squiller, Baldwin & Co., and assumed authority to sign this firm name to a promissory note which he gave in payment of his own overdue note. His conviction of forgery was set aside by the higher court. 34. In this case, the court states, the writing alleged to be forged in the case at bar was the handwriting of the defendant, known to be such, and intended to be received as such. It binds the defendant. Its falsity consists in the implication that he was a partner of Squiller and authorized to bind him by his act. This, though a fraud, is not, we think, a forgery. And in another case where the defendant fraudulently assumed authority to endorse a bill of exchange per procuration, Thomas Tomlinson, Emmanuel White, the 12 judges were unanimously of the opinion that the offense was not forgery. 35. Section 520. Fraudulently obtaining another's signature to a document. It has been held that it is not forgery fraudulently to obtain another's signature to a document. 36. Where the defendant was convicted of forging a promissory note, and the proof showed that he induced an illiterate man to sign the note, payable to himself for $141 by fraudulently pretending that it was for only $41. On appeal, the conviction was set aside. In the opinion, the court says, forgery is the fraudulent making or altering of a writing to the prejudice of another's right. The defendant was guilty of the fraud, but not of the making. The paper was made by the other person himself, in prejudice of his own right. To complete the offense, according to the definition, it requires a fraudulent intent and a making both. The latter is innocent without the former, and the former, if carried into effect without the latter, is merely a cheat. Section 521. Fraudulently filling in blanks. Where an agent is authorized by his principal to fill in the amount of a check signed by the latter in blank, and the agent fraudulently fills in a greater amount with intent to appropriate the excess, he is guilty of forgery. 37 But an agent who has general authority to insert the amounts in checks signed in blank, who fraudulently fills in greater amounts than required and appropriates the excess, is guilty of embezzlement and not forgery. 38. Section 522, fraudulently signing a false name. Forgery is committed where a person, with intent to defraud another, signs a false name to a check or bill of exchange. In such case it is immaterial whether the name signed is fictitious or not. Thus, where the defendant was convicted of forging a bill of exchange, and the proof showed that he purchased goods of the prosecutor and presented in payment therefore a bill of exchange signed in the name of a fictitious person, the conviction was affirmed. 39 Moreover, it is immaterial that the fictitious name signed is unnecessary. Thus, where the defendant was convicted of forging a bill of exchange, and the proof showed that he picked it out of the pocket of the owner and presented it at a bank for payment, that the clerk requested him to endorse it, which he did in the fictitious name of John Williams, that the clerk thereupon paid him the cash for it, the higher court affirmed the conviction. 40 In this case the judges were unanimously of the opinion that, although the fictitious endorsement was unnecessary to get the money, yet the offense was forgery, since the owner thereby lost the opportunity of tracing his property and the bank its endorser. Again, where the defendant signed the fictitious name John Williams to a promissory note and thereby fraudulently secured a loan of $85.50, having previously offered to give a mortgage on a team of horses in his charge, his conviction for forgery was affirmed. Section 523. Fraudulently signing name of a deceased person. Forgery is also committed where the name of a deceased person is signed to an instrument with intent to defraud. It is contended, inasmuch as Hathaway was dead at the time his name was signed to the check, that therefore the making of the false instrument cannot constitute the crime of forgery. The authorities do not sustain this position. On the other hand, so far as we have been able to ascertain, the contrary doctrine has been held to be the correct one, and adhered to wherever the question has been adjudicated. Section 524. Legal efficacy of document. To constitute forgery the document must be of legal efficacy, either real or apparent. Hence it is not forgery to make or alter a will which is not subscribed by the required number of witnesses, nor is it forgery to add names of witnesses to a document which the law does not require to be witnessed, nor to imitate a banknote which is declared void by statute. Some courts held that a letter of recommendation is capable of being forged. Other courts, however, hold the contrary. A note barred by the statute of limitations is capable of being forged since the statute to be effectual must be pleaded. 48 And for a similar reason a note purporting to be signed by a minor is capable of being forged, where an instrument is prohibited by statute under a penalty, but which is not rendered void. It is capable of being forged. But a city warrant which is void, 60 or an invalid contract owing to want of consideration, or a married woman's deed which is void for want of acknowledgement, or an affidavit not required by law, is not capable of being forged. Where a person fraudulently makes or alters a document, which on its face is apparently without legal efficacy, but which in fact, if genuine, would have legal efficacy, he is guilty of forgery. 54 Where a document is valid on its face, but invalid owing to some extrinsic fact, it is capable of being forged. For example, an insurance premium note which is to become valid when the policy is issued is capable of being forged although the policy is not issued. The same principle is applicable to a usurious note or bill of exchange. Mere misspelling of the signature attached to a note and intended to be regarded as that of another person does not prevent the offense from being forgery. Section 525. The document may be printed or engraved. It is not essential that the document be written. It may be printed or engraved. Thus, a railway ticket can be the subject of forgery. In the case cited, the defendant was convicted of forgery and the proof showed that he fraudulently procured innocent engravers and printers. In his absence, to engrave and print facsimiles of the tickets used on a railroad and disposed of the same. The definition of forgery at common law is quite sufficient to embrace the present case. It is then objected that the crime of forgery cannot be committed by counterfeiting an instrument wholly printed or engraved, and on which there is no written signature personally made by those to be bound. In the opinion of the court, such an instrument may be the subject forgery, when the entire contract, including the signature on the party, has been printed or engraved. Forgery may be committed with a typewriting machine. Section 526. Signing own name with intent to cheat. A person can commit forgery by signing his own name so as to make the document purport to be that of another. If the note is prepared for the purpose of being fraudulently used as the note of another person, it is falsely made. The question of forgery does not depend upon the presence upon the note itself of the indicia of falsity. If extrinsic circumstances are such as to facilitate the accomplishment of the cheat without the aid of any device in the note itself, the preparation of a note with intent to take advantage of those circumstances and use it falsely is making a false instrument. Section 527. Alterations and erasures. An erasure can constitute forgery as well as an interlineation. In either case, however, it must be material. It is forgery to erase a condition in a negotiable promissory note so as to render it non-negotiable. The maker of a note, in doing this to his own note after it is delivered, commits forgery. It is not forgery to add to a document words already implied by law. Thus, where a note is payable with interest, it is not forgery to add words stating the legal rate, because they do not prejudice the maker's rights. On the other hand, changing the middle initial of a person's name has been held a material change, and therefore forgery. $528. The intent. To constitute forgery, the act must be done with fraudulent intent. 66 And in England it has been held that the intent must be to defraud an individual. 67 In the case cited, the defendant was convicted of forging and uttering a college diploma. The proof showed that he procured a diploma that had been granted by a college of surgeons to another person, that he substituted his own name, changed the date, etc., announced that he was a member of the college, applied for the position of vaccinator at the poorhouse and offered to produce the diploma to establish his qualifications for the position. The conviction was quashed, however, on the ground that no particular intent to defraud any individual was proved. But it has been held in England that where the intent is to defraud one party and the act defrauds another, it constitutes forgery. 68 In this country the courts held that a general intent to defraud is sufficient. 69. Section 529. Doctrine of lucri causa not applicable. As in the crime of larceny, the doctrine of lucri causa is not applicable to forgery. It is not essential that the accused entertains any intent to benefit by the act. It is sufficient if he does the act for the benefit of another. 70 Moreover, it is not essential that anyone benefit by the act. Thus, the fact that a forged check is not accepted is immaterial, or that the person whose name is signed to it has no account with the bank. Section 530. Injury from forgery. To render a person guilty of forgery, it is not essential that the party whose name is forged has suffered any actual damage. Section 531. Similitude of false instrument to genuine. The mere fact that the forgery was so crude that it ought not to have deceived anyone is no defense. 74 Nor is the fact that the party whose name is forged has, in a few instances, paid checks where the accused had wrongfully signed the former's name,